Hello students, previous session we discussed regarding list of constitutional rights. Then the last right we have to discuss in this session, right to constitutional remedies. So Article 32 of the Constitution states that right to move the Supreme Court by appropriate proceedings for the enforcement of rights confirmed by the Constitution. So last right is in the nature of the remedy. So already we come to know that right to freedom, right to religion. So there are five rights already we have discussed. Regarding the protection of all those rights, we have to invoke this right, that is known as right to constitutional remedies. Article 32 provides protection of the right by filing a case before the Supreme Court or the High Court. So we can file directly either Supreme Court nor the High Court. Then we can protect our right by getting the court order. So the Supreme Court shall have the power to issue the directions or order to writs. Writ, W-R-I-T-S, writ, it means the order of the Supreme Court or the High Court in respect of rights, including writs in the nature of habeas corpus, mandamas, prohibition, quo warranto, certiorari, may be appropriate for the enforcement of any of the rights conferred by the Constitution. These are the five remedies are available under the Indian Constitution towards protection of our constitutional right. So in that, the first one, habeas corpus, it means to produce the body, and it is an order issued by the court to a person who has wrongly detained or restricted. If a person is illegally arrested, he can have the right to file a case before the court, then he can get it released back. That is known as habeas corpus. The courts can order for the concerned authority to produce the person physically who has detained, but it does not apply in case of criminals. So this provision is not applicable for the criminal. This provision is applicable who the person has not committed any crime, but illegally the police has arrested. That person is having the right to bring before the court of law. He can get released back. That is the first remedy available under the Indian Constitution under right to constitutional remedies. Then coming to the next remedy available in the Indian Constitution towards safeguarding the constitutional right, that is known as mandamas. It means we command. It is the command issued by the court to an official asking to perform his official duties that he has failed or refused to perform. It can also be issued against any public officer. So here, if a public officer has to discharge the duties according to the rules, regulations laid down in the government organization, suppose if the government officer has not acted on the basis of the rules and regulations incorporated in the organization, in the institution, if it comes to the knowledge of the court, then the court will issue the order to the public officer to discharge his one's own duties. For example, if a person or any of the person has applied for the license, so he has fulfilled all the necessary condition. In spite of that, the public officer has not issued the license, then the affected person is having the right to bring before the court of law, stating that that public officer has not discharged his power rightfully. So then the court will issue the order to the public officer to grant the license. So this way here we can get the proper remedy from the court. Then the third one is the prohibition. Prohibition means it means to forbid or to prohibit. It is issued by the higher court to lower court or tribunal to prevent the latter from exceeding its jurisdiction or jurisdiction that it does not possesses. The writ of prohibition can be issued only against judicial and quasi-judicial authorities. So here only the courts are having the power to protect the rights, isn't it? That is the Supreme Court as well as the High Court. Suppose if the lower court is having no power to provide any remedy in respect of breach of rights. Suppose if any of the lower court has started the proceedings in respect of breach of right, then if it comes to the knowledge of the Supreme Court will prohibit. That means the Supreme Court will stop the proceedings of the lower court, stating that that lower court is having no jurisdiction to entertain such petition. That is known as prohibition. Prohibition means stopping the proceedings in respect of breach of right on account of jurisdiction. Then the fourth one is the certiorari. It means to be certified or to be informed. It is issued by the higher court to a lower court or a tribunal, either to transfer the case pending with the latter to itself or to squash the order of the latter in case. So here the writ or the certiorari could be issued only against a judicial and quasi-judicial authority and not against administrative authorities. This is not applicable to the administrative authorities. So here certiorari means here it is issued by the higher court, that means the Supreme Court or the higher court, to tribunal, issuing stating that that case should be filed before itself. That means wrongly the case has been filed in the lower court. If it comes to the knowledge of the Supreme Court or the High Court, then it will issue the order to the lower court and transfer that case before itself and start the proceedings. That is known as certiorari. Then the last one is the quo warranto. It means that what authority or warrant it is issued by the court to inquire into the legality of claim of a person to public office. Hence, it prevents illegal use of the office by the public officer. So here it also realizes his duty. He has to discharge his duty according to the rules and regulations. So these all are the remedies available under the Indian Constitution towards safeguarding, protecting our rights. So this way here the fundamental rights are incorporated into the part 3 of the Indian Constitution by providing the overall development of the individual personality, because the rights are very essential. Without those rights, we can't live in a society. For the protection or well-being of our own personality, the constitutional framers have incorporated list of rights and given the legal sanction by considering those rights as a constitutional rights as well as fundamental rights. Not only the framers have incorporated the list of constitutional rights, in the same way, they also incorporated the protection by way of the right to constitutional remedies. Then coming to the other aspect, that is the incorporation of list of fundamental duties. How the rights are incorporated, it is the obligation of the state, because the state itself is the product of the human institution. So when the state itself is the product of the human institution, then the state has to provide certain liberties, though the state has provided the liberties in the form of granting the rights, no doubt. But our obligations towards the state, what are our obligations towards the state? We must follow certain liabilities, responsibilities in the form of duties. So the fundamental duties of the Indian Constitution are derived from the Constitution of USSR. In 1976, the Union government formed Saradar Swaran Singh Committee to go into the details of incorporation of fundamental duties. That committee has suggested 8 duties. The 42nd Constitutional Amendment Act of 1976 included 10 fundamental duties. In 2002, one more fundamental duty was added to the list. So, list of fundamental duties we'll discuss. So, Article 51, Subclause A, Part 4, Subclause A, incorporated list of fundamental duties. First one, The first duty to abide by the Constitution and respect of its ideals and institutions, the national flag, national anthem. That means we have to respect our national flag, institution, ideals and all. Then the second one, to follow the ideals that inspire the national struggle for freedom. Then the third one, to uphold and protect the sovereignty, unity, integrity of India. Fourth one, to protect the country and render national service whenever our nation requires our service during the time of the emergency. Then coming to the next one, to promote the harmony and the spirit of common brotherhood among all people of India. Then next one, to preserve the rich composite culture. Then next one, seventh one, to protect and improve the natural environment including the forest, lakes, river. Then next one, to develop the scientific temper, humanitarian and the spirit of inquiry and reform. Then ninth one, to safeguard the public property from any type of injury or destruction. We have to protect the public property. Then to protect the development of the individual personality. Then the next one, to provide the opportunities for education to his child or ward between the age of 6 and 14 years. This duty was added by the 86th Constitutional Amendment Act of 2002. So these all are the duties are casted in the form of obligation. It is our duty to incorporate all those duties towards leading a life in the society. So then the another significant right, that is the right to education, that is known as RTE. What is the meaning of RTE? It is nothing but right to education. The right to children to free and compulsory education, because the last right duty came into existence, that is in the year 2002 by way of constitutional amendment. That is the duty was added by the 86th Constitutional Amendment by providing free and compulsory education to the children below the age of 6 and 14 years. To that effect, this right has been came into existence. So here the universal elementary education plays an important role in strengthening social fabric in the democracy. So the directive principles of the state policy enumerated, not only the right has incorporated as well as the duty has been incorporated. Apart from the directive principles of state policy, also given the direction to the state that it is the duty of the every state to provide free and compulsory education to the children below the age of 14 years. Over the years, there has been an increase in the number of elementary schools, but the goal of universal elementary education is not yet achieved. So here the main aim of the state to provide the education to all the children, so that was not implemented, but particularly children from the disadvantaged groups and weaker sections are largely affected. So some people are, children are not get that type of the opportunity. For that purpose, to provide the equitable distribution by imparting all the children's, for that purpose only the state has incorporated or the constitution has incorporated by giving the direction to the all the state to provide free and compulsory education to all the children. For that purpose, hence the 86th Amendment of Act of 2002, Article 21, Subclause A was inserted to the Constitution, which provides for free and compulsory education to all children in the age group of 6 to 14 as a fundamental right. So, this is the fundamental right. It is one of the right incorporated by way of 86th Amendment Act of 2002. Then what the act says, what are the things are there in that? So consequently, the right of a children to free and compulsory education, the main aim of this right to provide the free education. To that effect, the Act 2009 was passed by the Parliament to bring into enforcement this concept fundamental right. So, the Act of 2009 was passed by the Parliament. In compliance of the Central Act, the government of Karnataka framed rules which were notified and came into force from 28th April 2012. So that day the act was implemented in Karnataka for providing free and compulsory education. Free education means that no child other than a child admitted by his parents shall be liable to pay any fee or charges or expenses which may prevent him from completing elementary education. It means that free education means that no child other than a child admitted by his parents shall be liable to pay any fee or the charges or expenses which may prevent him from completing elementary education. He need not pay any school fees because the exemption is there. The act itself has given the free education, so the children does not pay any money for getting the elementary education. So in this regard, the compulsory education cast an obligation on the concerned government. Not only it is the duty casted upon the parents to send their children to the school under the fundamental right, it is also one of the obligation casted upon the government to create such type of the educational elementary education, not only establishment of the elementary school and imparting the education without receiving any kind of donation or the fee. So, it is the duty of the government to provide free and compulsory education to the children below the age of 6 to 14 years. So, here the Act incorporated the characteristic feature to provide and ensure admission, attendance, and completion of elementary education, to ensure availability of the neighborhood school, then to ensure the child belonging to weaker section and the child belonging to disadvantaged group are not discriminated against and prevented from completing elementary education. So the duties of the government. So what are the duties are cast upon the government towards the enforcement of this act? So first of all, the central and the state governments are concurrent responsibility for providing the funds for carrying out of provisions of this act. So it is the duty of the state and the central government to implement by establishing such type of the schools. Then for implementing the provisions of this act, central and the state local government shall establish a school in the neighborhood nearby. They have to establish. Then the third one, the central government shall prepare estimates of capital and recurring expenditure and shall provide revenue to the state government as grant in aid. So the expenditure the state government has, central government has to prepare for the budget. How much money is required for the running the such type of the education, regarding everything it has to prepare the estimate. Then the fourth one, the government shall notify per child expenditure every year and shall reimburse fees of children admitted to private unaided school. So after the calculation, it has to reimburse the fees to the children. The concerned authorities, BEO, DDPI, are empowered to ensure admission to children from weaker section and disadvantaged group in the neighborhood privileged school. Then duty of parents, not only it is the duty of the government, not only it is the duty of the educational institution impart the justice, impart the education in the same way, it is the duty of the parents also to send their children to the school. So the act also says that it shall be the duty of every parent or a guardian to admit his child to an elementary education in the neighborhood schools. Then for protection of the children, certain remedies are also incorporated. for the regarding the protection of the children, whoever are studying under such institutions, under such education institution, for them the National Commission for Protection of Child Rights and the State Karnataka Commission of Protection of Child Rights shall have the power examine and review the safeguards for rights under this act, inquire into the complaints relating to RTE, taken necessary steps for protection of RTE. Any person having any grievance relating to RTE may make a written complaint to the BEO of the block, DDPI of the district, and the CEO of Jilla Panchayat, who shall examine the matter and pass orders as deemed fit. Therefore, the right of a children to free and compulsory education is believed to achieve equality and social justice and strengthen democracy through universal education. The main aim of the RTE to provide universal education to all the children below the age of 14 years. So, here with this we end. That is the fifth unit provides the awareness regarding the entire concept relating to the origin of the Indian Constitution. In that already we have discussed regarding the how the Indian Constitution came into existence. In this regard, the role of the Constituent Assembly, the role of the drafting committee, then the text of the Indian Constitution, what are the text states regarding the origin of the Indian Constitution in the nature of characteristic features as well as the salient features to the Indian Constitution. Then after that already we have discussed regarding the rights along with the duties, along with the significance of the right to get education. When this act came into existence, what is the significance of this act, what are the provisions are there in this act, how those provisions are safeguarded by the constitution by giving the power in the hands of the different institutions or the organizations or the officers to protect the RTE. So how it protects the democratic principles, all we have discussed under the unit 5, that is the Constitution of India. Next session we'll discuss regarding the next unit, that will be in the nature of organization of legislature.